Can I step out of the frame?
I know. That's why I never had anything else.
I'm out of it. You guys need to
Hey, just go. I literally have. You could have done this in a second.
Thank you. Thanks a lot.
Sorry, we have to negotiate.
Yeah, I'm not getting any more of it.
If you could start this slightly. Okay. Can you see your name?
My name is Aimée Craft, A-I-M-E with an accent E. Last name is C-R-A-F-T. I'm the Director of Research at the National Center for Truth and Reconciliation and I'm an assistant professor at the Faculty of Law at the University of Manitoba.
So today, the goal is that you want to get across to law students, future legal thinkers and writers. What is that message?
The message is that law in relation to Aboriginal people and Indigenous laws and Indigenous people is not a static law school experience. It's not something that you learn and then apply. It's a lifelong journey. And I think it's important to acknowledge that students and lawyers and judges have to be trained and continue to be trained to better understand the context of Aboriginal people, the interaction with Canadian law, criminal justice system, health, child welfare, etc. And also understand that there have been Indigenous ways of dealing with that for an extended period of time. We need to, as legal education as a whole, make more space for the understanding that exists that is valid. These students need to be aware of that, and they need to have the skills to engage with that system and those systems of law as they become lawyers.
I know that's difficult. Imagine a record, just turn it. I just want to make sure I'm here. Just this button, whatever, right?
Absolutely, we're going to talk about the ones that deal with justice, so recommendation or calls to action 27, 28, and 50. And 50 actually talks about our institutions, our relationship with the justice system as Indigenous people, and making sure that we have opportunities to foster understanding of Indigenous laws and places that we create access to justice in a way that's culturally and legally appropriate for Indigenous people.
That's all I have time for. You did great. You nailed the topic.
Are you guys ready to get started?
Yeah.
Okay, we're going to get started. First, I'd like to welcome everybody this afternoon. I'd like to welcome you to Treaty 6 territory in the traditional lands of the Métis Nation, and welcome you to the third Wunusweh, I'm trying to pronounce that accurately, lecture in Aboriginal law. My name is Chris LaFleur. I'm actually the acting director at the Native Law Center, and welcome you all to this lecture this afternoon. This lecture was established in 2011 following a generous lead donation from the Honorable Judge Gerald Morin, and the first lecture was held in 2012 as part of the College of Law's centennial celebrations. And I'd like to take this opportunity to thank Judge Morin and all those who have donated to make this lecture possible. As part of the McKercher lecture series, this program is intended to support an Aboriginal law or policy-related lecture by senior scholar and prominent lead advocates. This year's lecture features a panel which will examine truth and reconciliation in legal education, the TRC syllabus and Indigenous laws. This is an important area that we're going to be discussing today. And I'm glad of the big turnout, and I hope this isn't stop, but it's just continuing lectures that we're going to be going forward on and a lot of discussion. I'd like to begin this lecture by, I'd like to ask Maria Campbell, our cultural advisor at the College of Law, to bring greetings. Welcome, Maria.
Thank you, and I'm going to ask each of you, in whichever way you speak to Creator, to ask for blessing for this day and for the work that our sisters are doing. And law, especially Indigenous law, is really important in our community and in our lives. And it's really good to see so many of our own people, and especially sisters coming to talk to us. Help us make a better road for our babies. That's what Truth and Reconciliation was all about. So let's ask the Creator, our Mother, the Earth, and our first grandmother, and the four grandfathers to be with us today and to give us good energy and good life force. Matsun kapewihia. Equating tagok kapewichia huta kamyupaik. Angawiaski yakamina kuchigin kistamina kuchigin. Kawichia kakwena spetata. Haumina nohkom notugoata yokan kistamina kanaskom. Pevitabnan, pevichia chegogiskoak. Simsak. Atoskim katotavik. Hauka jote temagennan mosoma kaneopiik skotte mäkämöittäminen hannottavi temagennan kutsumina temagennan hei hei.
Before, I have to say I'm really nervous because I'm not used to doing this a lot. And so, I mean, full of professors and everything, and I don't come from an academic background, and all the knowledge up here, I'm very intimidated. So before I introduce our guest speakers, I'd like to take a moment to thank all those who contributed to this lecture, and including Judge Moran, but he was going to be here, but he's not here today, but he's going to be here tonight, so hopefully you guys run into him, say a big hi and thank you, okay? I think it's important. Anyways, I want to introduce our speakers. I'll start with Karen Drake. Karen is, and that's the one, Karen's in the middle, there you go. Karen's an assistant professor at the Burroughs Faculty of Law at Lakehead University and a citizen of the Métis Nation of Ontario. She is a co-editor-in-chief of the Lakehead Law Journal and a member of the Indigenous Bar Association's Board of Directors. Prior to joining Lakehead University, Professor Drake completed a clerkship with the Ontario Court of Appeal, where she clerked for Justice Stephen Borens, Justice Susan Lang, Justice Harry Laforme, and Justice Gloria Epstein. She subsequently served as judicial law clerk to Justice Leonard Mandamin of the Federal Court. So Professor Drake teaches Indigenous legal traditions, Aboriginal legal issues, and property law. Her current research interests include Métis legal issues. And I just wanted to mention that she is speaking tomorrow as well at the Native Law Center at 2 o'clock for those who want to come and see more on Métis issues. Secondly, Aimée Craft is Indigenous lawyer who joined University of Manitoba's Faculty of Law as an assistant professor in 2014. Her expertise in Anishinaabe and Canadian Aboriginal law, and she has an award-winning book, Breathing Life into the Stone Fort Treaty, focusing on understanding and interpreting treaties from an Anishinaabe legal perspective. She leads a project on an Anishinaabe water law, and I did read this. This was really interesting stuff. I was really happy to note that, the Anishinaabe, that the water has a spirit and has a voice, and I thought that's the type of tradition you want to bring forward, right, into the law, and that's really interesting. So in her decade of legal practice at the Public Interest Law Center, Aimée has worked with many Indigenous peoples on land, resources, consultation, human rights, governance issues. She's the past chair of Aboriginal Law Section of the Canadian Bar Association and was appointed to the Speaker's Bureau of the Treaty Relations Commission of Manitoba. Then I'm going to go on to Gillian Calder. She'll be, I think you're speaking first, aren't you? Yes, so she'll be speaking first. Gillian joined the University of Victoria Faculty of Law in 2004 from the perspective of Aboriginal law, from a practice of Aboriginal law in Vancouver. Some favorite work experience from her pre-UVic days include clerking at the BC Supreme Court, teaching at the University of New Brunswick. Oh, not yours, I think I had some friends that went at that time too. Since joining UVic, she taught the legal process, constitutional law, family law, civil liberties, the charter, advanced family law. Oh my God. I mean, vast amount of knowledge. She's deeply, I can't even imagine teaching one of those classes. She's deeply committed to the study of critical legal pedagogy and has been honored 4 times with the Terry Worcester Award for Excellence in Teaching. So I wanted to first introduce, I think what we're going to do is each speaker will speak individually, and then we'll have time to open it up for questions after. We have about an hour, so hopefully this all goes quickly as possible to get you to your 1 o'clock class, if you have one. If not, I'm sure we can sit and chat a little bit after. With that. Oh.
Thank you, and I'm nervous too, but I'm wearing my Princess Leia socks, and that seems to be helping me. Everything we do as legal educators involves our understanding of the places that we are. So I too would like to acknowledge the Treaty 6 lands and the Métis homeland, and I'm grateful to be a guest here, and I wanted to say a special thank you to Elder Campbell for that blessing and the wonderful ways in which we've been welcomed here so far. There are many thank yous to bringing a group together like this. And like many of you, intergenerational trauma impacts my life directly. So I'm deeply and humbly grateful to be part of this gathering, which is aimed at hope and knowledge and change. Let's see if this works. There we go. On June 17th last year, a young man opened fire on a church in Charleston, South Carolina. The shooter was white, and all 9 of the people murdered in the shooting were black. Amongst the many responses to this horrendous tragedy was the creation of a Twitter hashtag, Charleston Syllabus. It's created by Dr. Chad Williams, an associate professor of African and Afro-American Studies at Brandeis University. The goal, amongst many healing and other responses, was to crowdsource a set of resources that could be shared, taught, consumed, archived, connecting the events in Charleston to the larger systemic questions of racism in the United States, to connect the moments of racial violence that were emerging across the United States last summer, to legacy questions, and to draw on the energy of educators and academics using social media to create change. The response was swift and deep, 10,000 resource-rich tweets in the first day, and a series of actions that flowed from them to enable a more nuanced conversation about systemic racism to flourish. Quickly, it went from an effort to compile a list of readings on race into something more, a movement grounded in resources, conversation, education, history, and hope. A social media platform became a galvanizing medium, joining activists, academics, and a sorrow-filled public. On June 23rd, in the wake of several law schools across Canada, including my own, the University of Victoria, posting responses to the Truth and Reconciliation's 94 calls to action, particularly to Call to Action 28, the one that talks directly to law schools, I got a message from a lawyer in Vancouver, a woman named Aline Sigurdsson. She wondered if we might think about doing a reconciliation syllabus to try to generate a similar gathering of resources to further the work of the TRC. So as you know, in June of 2015, after many years of collecting evidence, the Truth and Reconciliation Commission of Canada released its executive summary, 388 pages, including 94 calls to action. The executive summary speaks generously and fiercely to all Canadians. It identifies many areas where change is needed to address the legacies of colonialism, genocide, and the residential school system. But initially, attention from the Legal Academy, from law schools, focused on calls to action 27 and this one, 28. Two provisions talking to law societies and law schools about what's needed as part of legal education to address the residential school legacy. The question ran the risk of just being about should we have a mandatory course at law school or not. But with this background, my colleague Rebecca Johnson, Aline, and I started to use social media. So I'm a tiny bit embarrassed, as if I'm a 52-year-old woman talking to law students about using social media, as if you've never heard of it, but in any event, let me just continue on. We started to tweet, and then we began to gather the resources in the ways that our colleagues in the United States had, and we generated a WordPress site, also called Reconciliation Syllabus. Our goal, similar to that work, is to appeal and connect legal academics to start to produce a thick range of materials across disciplinary boundaries that could enable law students to start to think about what they could do to respond not just to Call to Action 28, but to all of the 94 calls. How to begin to bring these serious questions thickly into legal education. We hoped that law schools across Canada would take up the challenge and talk to each other at the very least, thinking about how the legacies of colonialism are integrated into legal learning. We need to change what we do in our classrooms to offer diverse and respectful ways to embrace, so students can embrace their responsibilities as humane professionals. Reconciliation syllabus was, in this sense, as scholars have said in the United States, not just a hashtag, but a means through which to have a national conversation about colonialism, its imprints, its legacies, and the ways in which legal educators, law students, and lawyers can be part of that work. So our work here is ongoing. We've received some fabulous posts on diverse topics, like Karen's work here at Lakehead. The traffic is light, but the hashtag and the blog have been one mechanism through which our colleagues could start talking to each other. What do law schools need to do to ensure that they offer the mandatory course that the TRC calls us to offer, but we go to do that work further. And you can see what the TRC calls us to do is introduce law students to the history and legacy of residential schools, the UN Declaration on the Rights of Indigenous Peoples, treaties and Aboriginal rights, Indigenous law, Aboriginal Crown relations, as if that could be covered in a course. And while similar demands are made in other disciplines of medical schools and other places, the call is particularly significant for law. The commissioners reminded us, and I quote from the executive summary, the criminal prosecution of abusers in residential schools and the subsequent civil lawsuits were a difficult experience for survivors, made worse by the fact that many lawyers did not have adequate cultural, historical, or psychological knowledge to deal with the painful memories that the survivors were forced to reveal. Surely, nobody should graduate from law school today without those skills. So alongside a growing clearinghouse for resources to draw on to teach law, the site has enabled people to blog about the things that they've tried in the classroom. Again, trying to create a conversation across the resources of law schools. The stories of innovation there are another piece of what the TRC demands of legal educators. It reminds us that we often talk about legal skills as if there's a divide between the practical and the theoretical that we all understand. Call 28 reaffirms that skills training in intercultural competency, conflict resolution, human rights, and anti-racism are also legal skills. In my home faculty at UVic Law, the calls to action have been a trigger for conversations about what are we doing to meaningfully respond. So with the rest of my time, I just want to tell you a few of the initiatives that are underway at UVic Law, and hopefully that will feed into what my friends will talk about. I would say that as an institution, we try to accept and live by the words of the commissioners. They, again, I quote from the commissioners for the TRC, "Truth and apologies are achieved through words, but the next step, reconciliation, is achieved only by acting differently." We're proud of what we do as a law school, but a strong program only stays strong through critical reflection and reassessment. So we are in the throes of ground-up curricular review. We have two chairs, two Indigenous chairs, a Canada Research Chair in Indigenous Laws, and a Law Foundation Chair of Aboriginal Justice and Governance. And we have a robust set of courses, summer programming and workshops, commitments to weave questions of colonialism throughout the work we do. We took a step this year in January to bring our first-year class together and introduce them to the TRC. We canceled classes for 2 days, and we brought together a rich set of panelists, two residential survivors who grounded the 2-day workshop in presence and protocol and emotion, who gave them a direct conversation of experience but made visible the role that emotion plays. We had a speaker who talked about the legal structures that resulted in the 94 calls to action. Aimée and her colleague Rai Moran came from the National Center to talk about that work. A cultural anthropologist shared the work she's doing on the art she has collected from residential school survivors and the work that's being done to return the work to the children. And our chancellor at UVic, Sheila Rogers, who was an honorary witness to the TRC, closed us with the reminders that we all play as human beings. The day was emotional and effective, but for those of us who work at UVic Law, knowing that our whole first-year class had been introduced to the TRC makes a difference. The second day of the workshop was 2 exercises, put them back in the small groups that they had started the year with. And one part of the exercise was to imagine themselves as a federal government tasked with implementing the first part of the TRC. What kind of resources would they have to gather to do that work? The second part of the exercise, we constructed 10 short scenarios, each of which involved the students receiving a call from a community organization interested in how the calls to action apply to them. So those sites of work were like a grade 2 classroom, a central library thinking about renovation, a church group aiding an immigrant family, Silken Lauman and Steve Nash wanting to open the Sports Hall of Fame in Victoria, health workers wanting to implement a safe conception site. What, if some of those people came to you, what would you tell them about the TRC? What do the calls to action say to civil society as a whole? We wanted our students to become familiar and to understand what their roles were, not just as law students, not just as future lawyers, not just as people who will likely hold a lot of power in society, but as human beings. I forgot about this. Here we go. We also, at UVic Law, are really engaged with Call to Action 50. So on top of 27 and 28, we're thinking about what the role the federal government is being asked here to do, to fund the establishment of Indigenous law institutes for the development, use, and understanding of Indigenous laws and access to justice in accordance with the unique cultures of Aboriginal peoples in Canada. So what we're being asked here to do, it's an urgent call for institutional structures that can deepen our knowledge of Indigenous legal traditions. And law schools have a huge role to play there. At UVic Law, we have an Indigenous law research unit led by Dr. Val Napoleon, a team of researchers and students who are gathering, finding the internal strengths and resiliencies present in Indigenous societies, and doing work to honor those traditions. And we've been working for 11 years to deliver a degree in Indigenous laws. The work and dream of Dr. John Burroughs, a joint degree that would offer Indigenous and non-Indigenous students the opportunity to study Indigenous laws in conversation with the common law, offering pedagogical innovation through which more complex engagement with Indigenous legal orders as law and the development of solutions through that work for the social and economic disadvantages that often Indigenous people face. And recognizing that this work is hard and embodied, our school has worked to develop an amicus team that can support our students and recognizes the significance of cultural support in the journey that students take through law school. Commitment, imagination, capability, passion, courage, vulnerability, and desire. So to conclude, being involved in the TRC work as a legal educator has made it clear to me that our work is so much more than the question of whether there should be a mandatory course or not. It's to model the collaboration and innovation that the calls to action demand by understanding who is being spoken to and what is being asked of us. And it's to be better human beings. By doing that work, self-educating and supporting the initiatives of implementation wherever they might arise. Thank you.
Okay, how is this? Can you hear me okay? I have to start by apologizing. I thought that I might wake up and this cold would be gone, but instead I woke up and my voice sounds like this. So this is how I sound today. So Ani Bojo Tanche, hello. I want to start by thanking Elder Maria Campbell for her good words. I want to thank the organizers of this event for this opportunity. I want to acknowledge that we're on the territory of the First Nations of Treaty 6 and also the Métis homeland. Okay, so what I'm going to talk about, just to give you an overview, first, what are we doing at the Boer-Alaskan Faculty of Law at Lakehead University? So the newest law school in Canada, that's in Thunder Bay, Ontario. I'm going to talk about our initiatives to fulfill call to action number 28. Next, I've heard that there is some resistance to this notion that there should be a mandatory course dealing with these issues. I'm going to address some of those arguments. So one argument I've heard is that Indigenous law is just a niche area, and so how can we make it mandatory? I'm going to counter that argument. Next, I've heard this argument that we can't make it mandatory for courses to cover Indigenous laws because that would violate academic freedom. I'm going to counter that argument as well. Okay, so Professor Calder talked about some of the aspects of call to action number 28. Okay, that's great. How's that? Yes, okay, sorry about that. Okay, so at Lakehead, I think that, I'm not going to claim that we're completely implementing call to action number 28. However, I think that we are at least touching on all aspects of it. So, for instance, we actually have 3 courses dealing with Indigenous issues that are mandatory. The first one I'm going to talk about is Aboriginal legal issues. So this is a second-year course. It deals with Canadian law applied to Aboriginal peoples. It's mandatory. All of our students in second year take this course. It's a full-year course. So the things that we deal with in this course are the typical Section 35 jurisprudence issues, so Aboriginal rights, treaty rights, Aboriginal title. But from there we also talk about Section 25 of the Charter, we talk about federalism, we talk about Aboriginal identity issues, we talk about the Canadian Human Rights Act, how that applies to First Nations governments, and we also talk about the UN Declaration of the Rights of Indigenous Peoples. Okay, the next aspect of our program that's mandatory is a course called Aboriginal Perspectives. So this is a first-year course. It's an experiential learning course, and like I said, it's mandatory. All of our first-year students must take this course. So what happens in Aboriginal Perspective is that it's a pass-fail, and in terms of experiential learning, it means that students have to do a certain number of hours of credit. And what we do is we bring in elders and knowledge holders and have sessions for the students to attend. And then in addition to that, students fill the rest of their hours with other activities. So either through engaging in ceremonies that are offered by our campus, so powwows, for instance, sweat lodges, or else other activities that our faculty puts on. So we bring in other guest speakers, we bring in Indigenous leaders and Indigenous lawyers, we bring in residential school survivors as well. Okay, the last course that's mandatory in our program that deals with Indigenous issues is called Indigenous Legal Traditions. So this is mandatory for first-year students. All of our first-year students take this in the first semester of first year. So this is the course where we cover the laws of some Indigenous peoples. The ones that we focus on in our program are the Anishinaabe and the Métis, because that's the territory that we're in. So we start with Anishinaabe law, and we start with the stories, right? So the sources of law, some sources of law for the Anishinaabe are stories. Land can be a source of law as well. Ceremonies, of course. So we start with the Nanabijou stories, right? Nanabijou being the trickster for the Anishinaabe. And we cover them in a talking circle, right? So we were just mentioning how learning Indigenous laws isn't easily done in a classroom setting, right? It's not conducive to authority standing up at the front of the room and proclaiming what the law is. So we don't use that format. We use talking circles. Now, I mentioned the land as being a source of law for the Anishinaabe as well. So in order to receive teachings from the land in this course, one of the things that we do is we actually go out onto the land. So I've developed a relationship with members of the Fort William First Nation, which is located right beside Thunder Bay. And each year I take my course to Fort William First Nation. So we all get on the bus, we all pile onto the coach together, and we drive out to Fort William First Nation. And some of the members there, some of the knowledge holders, they take us to the sugar bush. And at the sugar bush, we receive the teachings that the maple trees have for us, right? Guided by the knowledge holders there. Okay, so from there in this course, we talk about Crown relations with Indigenous peoples, especially the Anishinaabe, and from the Anishinaabe perspective. So specifically, we talk about the treaty relationship. But in order to understand the treaty relationship, we need to first understand what the treaty relationship means to the Anishinaabe. And so to do that, we talk about treaty relationships between the Anishinaabe and other Indigenous nations, right? So for instance, with the Haudenosaunee Nation. So we also cover the Truth and Reconciliations report. And one way that we do that I found to be effective, because the first time I tried to do this, I stood up in front of the room and tried to talk about the report. And basically, it was the most tedious but also disturbing thing I've ever done, right? To just stand up in front of the room and talk about all these really, really terrible things that happened. So there has to be a better way to actually do this. So what I've found and what I can suggest is using a talking circle, right? So the students read the report beforehand, and then I have discussion questions for them. And then we go through that in a talking circle. Okay, so in terms of the modes of evaluation for this course, the modes that I've hit on are two that I want to talk about. The first is actually a talking circle assignment. So the students are divided into groups of 15, and in their group, they're given a fact pattern. And the fact pattern involves either a Métis or Anishinaabe nation, and there's all these legal issues that happen, right? There's all these problems, all these different things happen, but the key is that they have to solve the fact pattern using either Anishinaabe or Métis law, as the case may be, right? So I find that this is really helpful compared to the first time I taught the course, where we're just essentially writing essays about Anishinaabeg law. So, there's been this call to actually treat Indigenous law as law. If we're going to do that, let's actually practice using it to solve legal problems, the exact same way that we use the common law to solve legal problems. So that's what we've done. So they do this in a talking circle, which means that it's essentially an oral exam, right? So it's an oral exam, but solving a fact pattern. And then the final exam is very similar. So the final exam is also a fact pattern, but applying Anishinaabeg law to solve it. So what that does is it shows the students how they can actually use Indigenous laws in a practical and relevant way, right? I'm not just telling them that they're practical and relevant. They actually get to see the value by applying the laws themselves and solving current problems with them. Okay, so next the question, should Indigenous laws be a mandatory component of law school programs? And of course, the call to action number 28 says yes, but I've heard that there is some resistance. So I've heard some argue that Indigenous law is just a niche area. Only a tiny percentage of students are ever going to have to deal with Indigenous laws in their practice. It's not like constitutional law or, say, contracts where all practice areas are going to somehow intersect with it eventually. So that's the argument. The answer, though, the response I would give is that we've seen too many times the Supreme Court of Canada and some other courts as well over and over again saying that Aboriginal rights and Aboriginal title must be informed by the laws of Indigenous peoples, right? That's where the content of Aboriginal rights comes from, is from Indigenous laws. And yet we see over and over again when the court tries to actually apply Indigenous laws to interpret Aboriginal rights and Aboriginal title, they're not doing it. They don't actually engage with the Indigenous laws. So the most prominent example, of course, is the Marshall and Bernard decision, right? So there we have the court assuming that the Mi'kmaq simply have no laws regarding the exclusion of others from their territory. And yet John Burroughs points out in Canada's Indigenous Constitution that the Mi'kmaq do in fact have a sophisticated land tenure system that includes division of land into distinct districts. So what's happening here is that the judges, they're presented with stories, right, as sources of Indigenous law, but they can't see them as law. They don't see them as having normative force. Instead, they see them as just fables, maybe, children's bedtime stories. So this is a problem. And the thing is, out of all these students, you might know, okay, well, I'm never going to practice in this area. I don't really have an interest in Aboriginal law. But no one knows for sure who's going to be a judge. Right? Any law student could end up being a judge. So it's actually the person who never intends to practice in Aboriginal law who needs the mandatory course the most, because those people, those students, could end up being the judges who are then called upon to apply Indigenous laws and use them to interpret Aboriginal rights and title. So my students who take Aboriginal law in second year, when we go through the cases, they have no problem seeing all the places where the judges are unable to actually recognize Indigenous laws as being laws. It jumps out at them, right? They're mortified. Why can't the judges see this? Why can't they get it right? And they ask me, when is this going to change? When are the judges ever going to actually do what they say they're going to do, treat Indigenous law as law? And my answer to them is that it'll change when you become judges, right? It'll change when the people who have been trained to treat Indigenous law as law become judges. Okay, the other argument I've heard is that, I would contend that although read literally, call to action number 28 seems to contemplate a single course, I would argue that we should have Indigenous laws be incorporated into all mandatory courses. And in terms of resistance to this, I've heard that some are concerned that this would be a violation of academic freedom, right? We can't tell faculty what to teach that would violate their academic freedom. So my response to this is that this is a misconception of what academic freedom means, right? So academic freedom doesn't mean that you can't be told what topic to teach, right? So as faculty, we're given teaching assignments all the time. So if I'm told to teach property and I go and teach contracts instead, that's going to be a problem, right? I can't appeal to academic freedom to do that. So what academic freedom really means is that you cannot be required to take any given position on a topic, right? You can't be required to endorse any given position, and you can't be prevented from advocating for any given position. So what that means is that as a faculty, if you're given the job of teaching Indigenous laws as part of your course, you can take whatever position you want on it, right? You can take the position that you don't think Indigenous laws are a good thing, if that's what you want to do, but being given that teaching assignment itself is not a violation of academic freedom. And that brings me to my conclusion. Thank you.
Bonjour, Dinoy Maganik. Kiwed Neno Dine Koy Nishnikaz, Mikanaki Koy Nishnikaz. Manganando Dem, Manitoba Pain Donji, Chimegwich, Nea, Treaty 6, and Chimegwich, the Métis in your homeland territory as well. Very honored to be here today. The description of the lecture series said something about senior scholars and lifelong advocates, and I thought, ooh, how did I manage to find my way here today? If it said people that really care and that are thinking about this and want change and are prepared to commit to it, then I'm definitely in the right place today. And I'm looking forward to sharing some of my thoughts with you, and mostly hearing from you, so I'd like to save some time for questions. I'm, as was mentioned, an assistant professor at the Faculty of Law at the University of Manitoba, where our faculty council right now is dealing with Call to Action 28, and I'm not there. I'm here talking with you today. But I did share my comments in writing with them, and I'm hoping that they're going to have a very strong endorsement of what we're going to do as a faculty. And we're meeting next week in a forum for discussion, and I hope that you'll have continued opportunities for that discussion as well. I wear another hat, and that's as Director of Research for the National Center for Truth and Reconciliation. On a regular basis, people are telling us what they're doing on the calls to action. They're telling us what they're doing on reconciliation, how they're teaching the history and legacy of residential schools in their classrooms, and how they're working towards reconciliation in that way. But often people ask us, what can we do? And I'm going to tell you about something that we're working on, and I hope that you're going to feed into, and it ties to some of the work that Gillian was talking about in terms of monitoring the calls to action and seeing what's being done and building on what already exists. No need to reinvent the wheel on a regular basis. We can be inspired by the good work that's going on. So I'm very thankful for the Reconciliation Syllabus and for Lakehead's program, because what you're doing is sharing very generously with others what you're doing in a really amazing way in both of your faculties. So I wanted to acknowledge you both for that. The calls to action, there are only 94 of them, which somewhat surprised me. I thought we'd have an extensive volume. They're quite concise. They deal with health, law, justice, child welfare, and they are a complex web. They tie to each other. We see sports and media, some of the things you know, if any of you know the commissioners at the Truth and Reconciliation Commission, you may look at some of the calls and say, I know who called for that. I can see it. And that's wonderful. And it's based on a dialogue that's happened with the survivors and across Canada over an extended period of time. But you can't read those pieces in isolation. And that's what I'd like to talk about today, is not isolating Call to Action 28 as though somehow in your law school experience you're going to learn everything that you need to know about Aboriginal people and law, the United Nations Declaration on the Rights of Indigenous People, residential schools, Indigenous laws, and Crown Aboriginal relations. It is a continuing process. Now, Professor Calder mentioned that there are 2 calls to action that deal specifically with justice and that are aimed towards law students and the Federation of Law Societies, specifically about training lawyers. And those are important, and we need to acknowledge them, but we need to acknowledge the continuity and how they tie with the rest of those calls to action, because almost every single one of them, if you read them, has a legal implication. So you have a big task, because health practitioners may go look at the calls to action and see that they probably have about 15, just thinking offhand, 15 of them that relate to them. You have 94, and you have to read them together. Those are skills that you learn in first year law, am I correct? Reading together? Okay. And you have to keep doing that, and you have to keep learning through your law school experience, but also in your legal practice. And if you do become a judge, as Professor Drake is suggesting, then you need to keep learning, even things that you may have thought you would never deal with in your legal career. And the Federation of Law Societies has acknowledged, yes, they have this obligation to continue to train lawyers in accordance with 27, but the obligation to continue to learn is not a new thing for lawyers. Most law societies across Canada actually require continuing professional development and education. So this is a way to build on this continuity of legal education that exists already. What I'd like to share is that in your reading of the calls to action, pay attention to a few things. One is, what are the legal underpinnings of these calls to action? Where do I find law in that? And where do I find both substantive law, so what are legal obligations there? Where is it going to result in legislation, regulation? But where are some of the procedural elements of law in relation to Aboriginal people in that? So ask yourself that question, but also think about how the Truth and Reconciliation Commission approached the whole of its work. Because the calls to action are one piece that comes at the end, right? Has anyone read the final report in its entirety? It's a lot. Someone outside this room has read them. Or you're getting a message, a strong message, that you should be reading the entirety of the report. The University of Manitoba Press has just released A Knock on the Door. I wrote the afterword, Phil Fontaine wrote the foreword, and it's an abridged and condensed version of the executive summary. So if you're someone that cuts corners or you don't have much time, I'm not going to judge. You can go have a look at that. But keep in mind the structure when you're reading. You have the 94 calls to action that are the closing piece, but you have the history of residential schools as important. But your work doesn't end there. The TRC talks about the legacy of residential schools to situate us in where we are today. And that we need to know those two pieces to actually do the work of reconciliation. So you can't fly in and say, I'm going to work on reconciliation and I'm going to know reconciliation inside and out. You can't do that without knowing the first two pieces. And I'm actually going to suggest that you can't meaningfully work with the calls to action and gauge all 94 if you don't know the other pieces. And that's really what these calls to action are telling us, is that we need to have that understanding as lawyers, as legal practitioners, as judges. Now, continuity of legal education is important, as I mentioned. That's really the theme of what I want to share today. And I'd like to just bring up two examples of how I think that continuity has already been given effect and will continue to be. This is a place in Sagging, a place called Turtle Lodge. And you'll see at the table here that there are a few legal practitioners, elders that are advising the federal court,
And I don't know if you can actually see the judges in this picture. They tend not to let themselves be photographed. But there are judges sitting here. And this is a process, a multi-year process that was engaged with the federal court in an Aboriginal law bar liaison committee. We were developing guidelines for oral history and elders evidence in the courtroom. And the Indigenous Bar Association and Canadian Bar Association suggested very strongly to the federal court that they should be hearing not only from us, but from the elders about their experiences in court and what they thought the court should be considering as it developed these guidelines. Now, the elders made their way to Ottawa and shared very generously with the court. The messages were received. One of the strong messages being, we've come to your house, you have to come to our house. And so the court did. There was a great exercise in humility and sharing and Indigenous law in being in this place. I don't have time to share the ins and outs with you. I have one published article that talks a little bit about this process. But the ultimate result, and what I want to share coming out of this, is that the Chief Justice of the Federal Court at the time, Chief Justice Lutfi, said to the elders in the room, you have demonstrated to us that you have a living system of Indigenous law, multiple systems of Indigenous law, because these elders were from across Canada. And they said, no longer can we hide behind ideas that we have a bijuridical country, civil law and common law, but we are trijuridical or multi-juridical, and we need to consider and take seriously your laws as law. And the federal court has been very committed to that in bringing elders together, in doing judicial training. And some of it we know about, some of it is in discussions that are taking place that we might not be aware of. But there's a really interesting leadership that has come from this initiative at the federal court and from these elders that took their time to help advise the federal court in its work to understand what law actually was. Not just Indigenous people's interactions with the Canadian legal system, but what Indigenous law actually looked like. And how do we continue to do that? What does Indigenous law actually look like today? This is an example of how I describe law being everywhere. This is some of the research that I do on water that was introduced in the introduction. And this is actually when we were making offerings to the water at the end of our 4-day gathering. We've had 3 years of gatherings, five gatherings. We've actually taken our work with a faculty of elders that are responsible for this Anishinaabe, Nibi, Nakanagewin, Anishinaabe water law. We've taken that work out to one of our sacred places to work on water and water teachings. And we've built a wigwam teaching lodge that was meant to be a very humble lodge, but turned out to be 120 feet by 30 feet freestanding sapling structure. I know you might think in meters because you're a bit younger than I am, but that is a pretty big building. And we thought, we're a small group. How it's going to feel very empty in here. And yet it's always felt full. This past spring, we had over 150 people that attended to come and learn about Anishinaabe water law. Were they all Anishinaabe people? No. We had a lot of non-Indigenous people, scientists, world-leading scientists on water, community advocates, and children coming to learn. And we were not only learning about law, but practicing law and being in the same space for 4 days, actually engaging with these values, these procedural laws, these substantive laws, and the internal regulation and external regulation of water based on our own legal values and principles. So I want to close by saying that for myself, law is a lifelong journey. I started at the age of 9 years old, writing out criminal legal cases at my desk in my bedroom, and my dad would say, "What are you doing?" "It's okay, Dad, I'm just writing out a murder case. I'll be right with you." But that evolved, and I wanted to do environmental law, and I went to law school and learned how Indigenous people's interaction with law was at that time, and said, no, this is the path that I need to take. And I look at this very much as a continuing learning opportunity, and I hope that you'll join me in that continued learning, and that you'll create time in your classroom experience, in your law school experience, as lawyers, as judges, but as Anishinaabe, or as people in your interactions with yourself, the people around you, and your environment. There isn't one path to reconciliation, there are multiple paths. Keep in mind the law that's around you, have an openness to it, and continue to learn. Those are the things that I ask humbly of you today. Aimée.
Okay, we have a few minutes for questions. So, anybody? This is a big topic. Lots was said today. Very interesting stuff. I have my own questions, but I may save them until the end. But does anybody have any questions for our panelists? And
thank you very much for your presentation. This university has heeded the calls to action and gathered the receptivity around the notion of indigenizing the institution. And that has had two distinct effects. One has been to galvanize people in the academic community of goodwill who are not entirely certain what indigenizing will mean, but know it has to happen, and hope that they work together, it can take a form that people can use in transformative ways. But whenever there is innovation or transformation, there is also resistance. And there is really quite challenging nodes of resistance across the campus. Some of these are on the universal ground Professor Drake raised, of academic freedom, behind which is this claim to pedagogical sovereignty, which is conditioned and given away, traded all the time. So it's not a ground. However, there is a powerful appeal. Who's against academic freedom? So what that does is set up a kind of discursive context that's really quite challenging. Then there's a question of the niche, and the niche plays differentially across campus. In some areas, teaching ultra-colonial instrument like English literature, we've got a lot to live down. We have to renegotiate center and margin so that the niche becomes the center in ways that help us all. There's also a disciplinary essentialism. In our faculty council, someone asked about indigenization. Someone from Ag Bio, and of course agriculture and biotechnology are entirely innocent of any colonial activity. So it's coming from a very pure space, right? But the person said, well, should this is the mandatory incorporation of the Indigenous across the curriculum. Will that apply to masters and PhD persons? So the idea is that you insulate yourself in the name of sophistication against the common enterprise that most of us are trying to undertake. Do you have any thoughts about law in particular as a place of transformation, but also as a place of resistance?
I think that what's behind much of the resistance is a lack of expertise, right? In order for us to stand up in front of a classroom and be the professor on that topic, we have to have some expertise. And we're calling on people now to teach Indigenous laws as law, and we're calling on that to be integrated throughout the curriculum. And many people don't have that expertise. And what are they going to do? How are they going to learn it? It's going to take a lot of time. And when it comes to Indigenous laws, the sources of Indigenous law are not the same as the sources of the common law. There's no book that you open up and, oh, there's all of Anishinaabeg law right there in some one spot, right? Or you don't just go to the interwebs and find all of Anishinaabeg law set out there for you. To learn Anishinaabeg law, you have to go to the ceremonies, right? You have to, when a drum is offered to you, you accept the drum and you learn the songs, right? Or you go to the powwow and you dance the dances. And you listen to the elders, and you go on to the land, and you listen to what the elders teach you. And all of that's incredibly time-consuming, and it's not easy. It's not easily accessible. So when we're calling on people to do this, there's also this tremendous responsibility on those of us who have some idea of how to do it to guide others, right? We have this tremendous responsibility to show other people how to go about learning Indigenous laws and to facilitate that and to make it more accessible for all of our colleagues and to all of the other faculty that we want to be incorporating this information into their courses.
Oh, can I just say something? Oh, sorry.
That was my long pause of thinking about how it, but go ahead.
I just have one brief thing to add, which is I think we are incredibly conservative in teaching law. That it's not about getting law schools into the 21st century, it's about getting them out of the 19th. And that law students today are very different kinds of learners than even the 15 years ago when I was at law school. Like it's a completely different way of being. They're visual learners, they're kinesthetic learners, and we have to figure out how to teach in a way that reaches, that connects, and that is, once we do that kind of work, once we figure out how to be better teachers, and then we can engage with the more difficult questions of what, it's hard to think about teaching Indigenous law as law through the, as Karen said so eloquently, when we're just standing and trying to, teach at. It doesn't work. So there's broad changes that need to be happening, and we as legal educators should be rising to that challenge. We should be thrilled by the opportunity to rethink things, but instead I think some of it just comes from the conservative nation of how we were taught ourselves.
So the idea of indigenizing university can't be abstracted from the idea of decolonizing a university, right? And there's great scholarship and advocacy around the idea of if you're imposing a layer on top of a colonial institution of Indigenous perception, that you're red-washing a university, and how valuable is that? And I think that needs to be said, that needs to be explicit, and that there has to be an underlying commitment to decolonize while indigenizing, and that needs actually to be expressed. So that's the place that I start from. Part of that is how you approach teaching law. I am not an expert in Anishinaabe law. Never will I be in my lifetime. I have a commitment to know as much about it as I can, to work for it. I know that a lot of the elders that I work with will say, I am not an expert in Anishinaabe law. I know a small piece. And that's part of the humility and the worldview and that idea that you're learning. And that there's a lot that you don't control in relation to your environment, in relation to this body of knowledge and the responsibilities that you carry. So it's decolonizing the worldview of law to say, as someone who's teaching, I stand in front of you with all this expertise and this wisdom that I'm going to impart, and rather saying, here are some of the questions that I have, here are the things that I'm thinking about. And like Karen's saying, here are the people that are going to connect us to that further learning. So that, not everybody will have a chance to go to a powwow or go into ceremonies, and not everyone will feel comfortable or want to do that work, but that they have the opportunity to connect with those people and bring in that knowledge, and that it's not housed in one place, and it's not housed in one institution, right? Which is what I was showing you. That work is supported by the University of Manitoba, and it's far from the campus. It's in a completely different way of approaching it, but it's in an Anishinaabe way. And so we need to have that decolonization and that indigenization working hand in hand and continuously providing that check and balance, in my view. We're trained to see law and think about law, not to know law, because we're outdated in 1 second. It's almost like technology, really.
to really bring the Indigenous side into the practice. And I'm just going to give you an example. A lot of times in a negotiation session, you're starting with